Here's what most employers don't realize. 3 major employment law shifts just happened that could completely reshape how you handle wage disputes, compliance audits, and worker classifications. And the ripple effects are only beginning. Welcome to this week's deep dive into the most significant employment law developments that every business leader needs to understand. As part of our ongoing Workforce Wednesday series, we're unpacking game-changing updates that emerged from federal courts and the Department of Labor. Changes that could either become your biggest compliance headache or your strategic advantage, depending on how quickly you adapt. You can catch the full discussion on virtually any podcast platform you prefer, including Amazon Music, Apple Podcasts, Spotify, iHeartRadio, and YouTube Music, among many others. But here's what you need to know right now about these 3 critical developments. The 7th Circuit just rewrote the playbook for worker class actions. The U.S. Court of Appeals for the 7th Circuit just dropped a bombshell that's sending shockwaves through employment law circles. They've established what they're calling the Richards Framework, essentially a compromise approach for handling Fair Labor Standards Act collective action notices. But here's where it gets controversial. This decision has actually deepened the existing disagreement between different federal circuit courts about how these notices should work. Think of it like having different rule books for the same game, depending on which state your business operates in. This inconsistency is so pronounced that legal experts are now predicting the Supreme Court might have to step in to settle the dispute once and for all. What does this mean for your business? If you're facing potential collective action lawsuits from employees claiming wage violations, the court where your case gets heard could dramatically impact the outcome. The Richards Framework represents a middle ground approach, but whether that's good or bad news for employers depends entirely on your specific situation and location. Here's the part most people miss. This isn't just about current lawsuits. These notice standards affect how easily workers can band together to challenge your wage practices in the future. The more lenient the notice requirements, the easier it becomes for employees to organize collective legal action against employers. The Department of Labor's surprising olive branch to employers. In what might seem like an unexpected move, the Department of Labor has relaunched something called the Payroll Audit Independent Determination Program. And this time, they're being more generous with employers than many anticipated. This program essentially allows companies to come forward voluntarily and confess their wage and hour violations before getting caught, in exchange for avoiding the nightmare scenario of full-scale litigation and those punishing liquidated damages that can double your liability. Think of it as the employment law equivalent of a tax amnesty program. But here's what's really interesting. The DOL has expanded this program to now include certain Family and Medical Leave Act violations too. This suggests they're genuinely trying to encourage voluntary compliance rather than just catching employers in gotcha moments. The controversial question nobody's asking, is this actually a trap? Critics argue that self-reporting through this program creates a paper trail that could be used against employers later, even if they're promised immunity. Others see it as a genuine opportunity to clean up past mistakes without devastating consequences. For businesses that have been operating in gray areas of wage law, and let's be honest, that's more companies than care to admit, this program could be either a lifeline or a liability. The challenge lies in determining which violations are worth self-reporting and which might be better left undiscovered. A surprising shift in how wage investigations are handled. The Department of Labor has quietly issued new guidance that significantly dials back the penalties employers face during wage and hour investigations. And this change is flying under the radar despite its huge implications. Under the new directive, those dreaded liquidated damages that essentially double your back pay liability won't automatically apply during pre-litigation investigations. However, and this is crucial, the DOL can still pursue these enhanced penalties if your case escalates to actual court proceedings. This creates a fascinating strategic dynamic. The DOL is essentially incentivizing employers to cooperate and settle during the investigation phase rather than fighting things out in court. But is this carrot and stick approach actually fair? Or does it pressure employers into settling even when they might have valid defenses? The controversial angle here is that this policy seems designed to streamline the DOL's workload by encouraging quick settlements, but it also might be denying employers their day in court. Some legal experts argue this puts undue pressure on businesses to admit wrongdoing and pay settlements even in questionable cases, simply to avoid the risk of double damages later. Other employment law bombshells you need to know. President Trump's recent executive order has completely reversed the previous administration's approach to non-compete agreements, essentially returning federal policy to a hands-off stance that lets states set their own rules. This dramatic policy whiplash demonstrates just how much employment law can change with political winds. Meanwhile, Illinois is breaking new ground by requiring employers to provide paid leave for military funeral honor details, a development that could signal a broader trend toward expanded military leave protections nationwide. And in the benefits world, 401k plan administrators are grappling with increasingly complex questions about ESG investments, cryptocurrency options, and alternative assets, decisions that could expose employers to entirely new categories of fiduciary liability. The bigger picture and what it means for your business. These developments collectively paint a picture of an employment law landscape in rapid flux. We're seeing simultaneous trends toward both enforcement flexibility, like the paid program and reduced investigation penalties, and increased complexity, like conflicting court standards and expanding leave requirements. As a trusted authority in U.S. employment law, firms like Epstein Becker Green are helping employers across diverse industries navigate these shifting requirements while protecting their reputations and bottom lines. The key is staying ahead of changes rather than reacting after problems emerge. Our Employment Law This Week series continues to break down these complex developments every Workforce Wednesday, making them accessible and actionable for busy business leaders who can't afford to miss critical updates. But here's the million-dollar question that's sparking heated debates in legal circles. Are these recent changes actually making employment law more fair and predictable? Or are they creating new forms of uncertainty that put both employers and employees at greater risk? Some argue that voluntary compliance programs and reduced investigation penalties show a more reasonable, business-friendly approach to enforcement. Others contend that inconsistent court standards and frequently changing policies create an environment where following the law becomes a moving target. What's your take on these developments? Do you see the DOL's softer approach to investigations and self-reporting as a genuine attempt to improve compliance, or as a strategic move that ultimately benefits the government more than businesses? And with different federal courts applying different standards to the same types of cases, how can employers possibly maintain consistent compliance strategies across multiple jurisdictions? These aren't just academic questions. They have real implications for how you structure your wage practices, handle employee complaints, and assess legal risks. The answers might determine whether your business thrives or struggles under the evolving employment law framework. Share your perspective. Are these changes moving employment law in the right direction, or are we creating more problems than we're solving? Your experience and insights could help other business leaders navigate these challenging waters.